The two questions raised by Crucians in Focus were whether or not Senator Alicia Hansen was a qualified voter in 2010 and thus eligible to run for office, and whether her recent conviction was a felony or a crime of moral turpitude. The Attorney General's answer, while clear, still leaves a lot open to interpretation, and he says it should be left to the Senate to decide Hansen's fate. Two of the 6 requirements to be a member of the Senate, as defined by the Revised Organic Act of 1954, says a person must be a qualified voter of the VI and not been convicted of a crime of moral turpitude. Was Hansen a qualified voter at the time? The Attorney General says yes. Every VI resident who is a U.S. citizen and 18 or older can vote. However, one limitation cited in the VI Code says persons convicted of a felony or moral turpitude crime can't vote for 1 year following the date of their discharge. Hansen was convicted in May 2009 of 3 counts of failure to file income tax returns, none of which carried a penalty of more than 1 year. The penalty for a felony is more than 1 year. The Attorney General said moral turpitude is not specifically defined by VI law. However, it is referred to in several sections of the code as a crime involving dishonesty. He went on to say that tax evasion in other jurisdictions has sometimes been considered a crime of moral turpitude, but Hansen's conviction is not the same as a tax evasion conviction, though failing to file could show a pattern of dishonest conduct. The AG said the supervisor of elections was responsible for certifying the candidates listed on the ballot. Once a majority of voters elected those candidates and the board certified the results and sent them to the election supervisor, their jurisdiction ends. As a senator now, whether Hansen stays or goes will be left up to her colleagues. Erica Parsons, News 2.